Brown versus United States, May 15, 2023. Thank you for listening in. While listening to the case, consider how the judges in this 6-3 opinion view how statutory cross-references operate. How does this opinion mesh with the traditional notion of plug-and-play cross-references? This is the full opinion audio, and Justice Alito delivered the opinion of the court. These cases concern the application of the Armed Career Criminal Act to state drug convictions that occurred before recent technical amendments to the federal drug schedules. The Armed Career Criminal Act imposes a 15-year mandatory minimum sentence on defendants who are convicted for the illegal possession of a firearm and have a criminal history that is thought to demonstrate a propensity for violence. These defendants are subject to the Armed Career Criminal Act's enhanced penalty if, among other things, they have 3 previous convictions for a serious drug offense. For a state crime to qualify as a serious drug offense, it must carry a maximum sentence of at least 10 years imprisonment, and it must involve a controlled substance as defined in Section 102 of the Controlled Substances Act. The Controlled Substances Act, in turn, includes 5 schedules of controlled substances and provides that these schedules must be updated each year by the Attorney General. The 2 cases now before us present the question whether a state crime constitutes a serious drug offense if it involved a drug that was on the federal schedules when the defendant possessed or trafficked in it, but was later removed. We hold that such an offense qualifies. In 2016, Justin Rashahad Brown sold cocaine to police officers in a series of controlled buys. The officers conducted 2 warrant-authorized searches of Brown's home, where they discovered cocaine and a loaded .38 caliber revolver. In 2018, a federal grand jury returned an indictment charging Brown with several drug offenses, as well as possession of a firearm by a convicted felon. Brown pleaded guilty in 2019 and was sentenced 2 years later. At sentencing, the probation office recommended that Brown receive the Armed Career Criminal Act's mandatory minimum sentence because he had 4 prior Pennsylvania convictions for possessing marijuana with intent to distribute between 2009 and 2014, as well as 1 Pennsylvania conviction for distributing cocaine in 2008. Brown disputed this interpretation of the Armed Career Criminal Act and argued that his marijuana convictions did not involve a controlled substance as defined in the Controlled Substances Act. A state drug offense counts as in the Armed Career Criminal Act, predicate only if the state's definition of the drug in question matches the definition under federal law. When Brown was convicted for possessing marijuana, both federal and Pennsylvania law defined marijuana to include all parts of the plant Cannabis sativa L, so the definitions were a categorical match. But while Brown's federal charge was pending, Congress enacted the Agriculture Improvement Act of 2018, which exempted some hemp, a variety of Cannabis sativa, from the federal definition of marijuana, because the federal and state definitions did not fully match when Brown was sentenced. He argued that his marijuana convictions no longer qualified as serious drug offenses. The district court disagreed and sentenced him under the Armed Career Criminal Act, and the Third Circuit affirmed. It concluded that the 2018 amendment did not apply retroactively to federal offenses committed before its effective date. Under the Third Circuit's view, Brown was properly subject to the Armed Career Criminal Act's enhanced penalties because he violated 922G when the federal and state definitions of marijuana were a categorical match. Brown was properly subject to the Armed Career Criminal Act's enhanced penalties because he violated 922G when the federal and state definitions of marijuana were a categorical match. In 2017, Eugene Jackson noticed a police car arriving at the Sparkle Food Market to execute an unrelated search warrant, and he responded by fleeing and discarding a loaded .45 caliber pistol. Officers eventually identified Jackson as the gun's owner, and in 2019, he was charged with possession of a firearm by a convicted felon. He pleaded guilty and was sentenced in 2021. Jackson's pre-sentence report identified several prior Florida convictions as the Armed Career Criminal Act predicates, including convictions in 1998 and 2004 for possession and distribution of cocaine. But Jackson, like Brown, claimed that these convictions were not for serious drug offenses. When those crimes were committed, the federal government and Florida defined cocaine the same way. But in 2015, the federal government legalized a radioactive cocaine derivative called 123-loflupane. That is the active pharmaceutical ingredient in a drug used to diagnose patients who are suspected to have Parkinson's disease. So when Jackson committed his federal offense, the federal and Florida definitions were no longer a categorical match. The district court found that Jackson's prior convictions qualified as serious drug offenses and sentenced him to the Armed Career Criminal Act's mandatory minimum. On appeal, the 11th Circuit initially disagreed and vacated Jackson's sentence. But a few months later, the panel sua sponte vacated its opinion, ordered supplemental briefing, and in a new opinion, affirmed the district court. The 11th Circuit reasoned that a prior drug conviction is in the Armed Career Criminal Act predicate if the state and federal definitions of the drug matched when the defendant committed the state offense. We granted Brown's and Jackson's petitions for a writ of certiorari and consolidated the two cases. We now affirm. These cases ask what 18 U.S.C. 924E2 means when it refers to a prior state drug offense involving a controlled substance as defined in Section 102 of the Controlled Substances Act, and specifically whether the federal and state definitions of a drug must match when the state crime is committed or at some later point in time. The parties propose three different answers. The government argues that a prior state drug conviction qualifies if the federal and state definitions of the relevant drug matched when the defendant committed the state crime. Therefore, even if the federal and state definitions are different, when a defendant violates the federal felon in possession law or is sentenced under that law, earlier state convictions that occurred during the period when the federal and state definitions were the same nevertheless qualify as serious drug offenses. Jackson, by contrast, argues that the federal and state definitions must match when the defendant violates the federal felon in possession statute. In his view, it does not matter whether the federal and state laws both criminalize the relevant drug when a defendant possessed or trafficked in it. If the federal government later narrows its definition of that drug, no state conviction under the broader definition counts against a defendant who later commits the federal firearm offense. This interpretation would mean that Jackson's two cocaine convictions are no longer serious drug offenses because, years later, the federal government narrowed the definition of cocaine in the federal schedules to legalize a Parkinson's drug derived from cocaine. In fact, under Jackson's and the dissent's interpretation, no Florida cocaine convictions obtained before July 1, 2017, when Florida also legalized the derivative, would count. That would be true even for convictions involving the possession or distribution of huge shipments of cocaine base. And as other courts have noted, cocaine convictions under the laws of many other states would likewise be affected. These cocaine convictions would be excluded even though it is highly unlikely that any were based on the possession or sale of the Parkinson's drug. That derivative is radioactive, so it can be produced only through a highly technical and complex synthetic route, and the drug in which it appears can be stored for no more than 24 hours. Furthermore, anyone attempting to become intoxicated by using the drug would need to inject nearly 6,000 vials, or 15 liters of fluid, a volume likely to cause death if administered intravenously. Unsurprisingly, the federal government has identified no case reports involving individuals who misused that drug or any other ioflupane-containing product. Brown offers a third option. He contends that the federal and state definitions must match when the defendant is sentenced for the federal firearm offense. Under his interpretation, it does not matter whether the two definitions matched when a defendant previously violated state law, or even when he or she committed the federal firearm offense. As he sees it, if the federal authorities narrow the definition of a drug at any point before sentencing, The prior state convictions no longer count as the Armed Career Criminal Act predicates. This interpretation would produce strange results in cases involving long criminal investigations or prosecutions. In this case, for example, Congress adopted the partial exemption of hemp nearly 9 months after Brown was indicted, and more than 2 years after he violated 922G. Under his proposed interpretation, he is exempt from the Armed Career Criminal Act's mandatory minimum only because his prosecution did not move more quickly. Indeed, Brown's interpretation could result in very different sentences for co-defendants who committed the same state marijuana offense on the same days and likewise committed the felon in possession offense at the same time. Under Brown's interpretation, if one co-defendant was sentenced on December 19, 2018, one day before the Agriculture Improvement Act was signed into law, and the other was sentenced on December 21, the day after enactment, the Armed Career Criminal Act's 15-year mandatory minimum would apply to the first but not the second. We must decide which of these three proposed interpretations is correct. Standing alone, the operative phrase involving a controlled substance, as defined in the Controlled Substances Act, does not definitively answer that question, but precedent and statutory context show that the government's interpretation is correct. The Armed Career Criminal Act is a recidivist statute that gauges what a defendant's history of criminal activity says about his or her culpability and dangerousness. It does this through a backward-looking examination of previous convictions that bear on dangerousness. Thus, as we explained in McNeil, the Armed Career Criminal Act requires sentencing courts to examine the law as it was when the defendant violated it, even if that law is subsequently amended. In McNeil, the question was whether a prior state drug conviction was for a crime that carried the maximum penalty needed to qualify as a serious drug offense, i.e., imprisonment for 10 years or more. To answer that question, we looked back to the law under which the defendant was convicted and concluded that a subsequent statutory amendment reducing the maximum penalty below the 10-year threshold did not matter. This backward-looking approach supports the government's interpretation here. The plain language of 18 U.S.C. 924E2A1, the provision that immediately precedes the provision at issue here, points to the same conclusion. Section 924E2A1 defines a serious drug offense to include certain federal drug crimes, namely, offenses under the Controlled Substances Act or 2 other federal laws. Any crime contained in the Controlled Substances Act is an offense under the Controlled Substances Act. The standard judgment in a criminal case used in federal courts indicates whether a defendant was convicted and sentenced for such an offense, and a later change in a federal drug schedule cannot change that fact. The government's interpretation would treat state offenses involving a controlled substance as defined in the Controlled Substances Act like those federal offenses under the Controlled Substances Act 924E2. Petitioners' interpretations, by contrast, would treat those federal and state offenses differently. Consider a defendant who was caught distributing cocaine on back-to-back days, was charged with a federal crime for the first day's offense and an identical state crime for the second, and was convicted of both before the 2015 amendment that deleted Parkinson's drug from the definition of cocaine. Under petitioners' interpretations, the federal offense would remain in the Armed Career Criminal Act predicate, but the state offense would not, even though the crimes and the statutes of conviction were otherwise identical. That is a very strange reading of 924E2A1 and 2. Both subsections refer to prior offenses relating to the Controlled Substances Act, and in 924E2, Congress clearly indicated that past conduct that violated the Controlled Substances Act is probative of a defendant's culpability and dangerousness, even if the federal drug schedule is later amended. There is no reason to think Congress reached a different judgment as to petitioners' conduct merely because they had been convicted under a state rather than federal statute. Indeed, it would be unnatural to give back references to the Controlled Substances Act starkly different interpretations. The government's interpretation also best fulfills the Armed Career Criminal Act's statutory objectives. Congress's general approach in the Armed Career Criminal Act was to single out offenses of a certain level of seriousness that involve violence or an inherent risk thereof, and that are likely to be committed by career offenders. Because defendants who have repeatedly committed the Armed Career Criminal Act predicate offenses are especially likely to inflict grave harm when in possession of a firearm, the Armed Career Criminal Act imposes a higher punishment when they do so. A defendant's history of criminal activity does not cease to exist merely because the crime was later redefined. It therefore makes sense to ask, as the government does, whether a prior offense met the Armed Career Criminal Act's definition of seriousness and thus suggested future danger at the time it was committed. Petitioners and the dissent disagree. As Brown puts it, when the federal government changes the federal drug schedules, it necessarily concludes that the descheduled substance does not implicate the culpability or harm that federal law previously attributed to it. Of course, Brown and Jackson were themselves convicted of crimes involving substances that are still on the federal schedules, marijuana and cocaine, not hemp or ioflupicin. But even setting that aside, their argument misunderstands the theory on which the Armed Career Criminal Act is based. A prior drug conviction for an offense punishable by 10 years imprisonment augurs a risk of future dangerousness, even if the drug is no longer considered dangerous. That is because the conviction reveals that the defendant previously engaged in illegal conduct that created a dangerous risk of violence, either with law enforcement or with others operating in the same illegal field. If left at large, such defendants present a serious risk to public safety. That risk does not cease to exist if the law under which the defendant was convicted is later amended or eliminated. For example, consider a person who distributed alcohol during Prohibition. The later legalization of alcohol did not by any means ensure that these bootleggers would take up legitimate jobs. Instead, after the end of Prohibition, many of them simply shifted to other illegal enterprises. Likewise, Brown's and Jackson's multiple convictions for serious drug crimes are evidence that they may continue to commit a large number of fairly serious crimes as their means of livelihood in the future. And that risk remains true, despite the technical changes to the federal drug schedules on which their arguments hang. For this reason, the court has previously rejected similar arguments about the Armed Career Criminal Act's rationale. Like petitioners here, the petitioner in McNeil argued that a later reduction in the maximum sentence for his offense reflected a legislative judgment that his prior offense was less serious than previously thought. And this, he suggested, meant that the offense should no longer be treated as serious under the Armed Career Criminal Act. We termed that argument absurd. The subsequent change in state law did not erase earlier conviction, and it was the fact of that earlier conviction, not the legislature's subsequent judgment, that the Armed Career Criminal Act was concerned with, because that fact demonstrated the defendant's culpability and dangerousness. Petitioners and the dissent make various other arguments, but none is persuasive. Jackson mainly relies on two interpretive tools. He begins with the so-called reference canon. This canon, he claims, means that the Armed Career Criminal Act incorporates the schedules as they exist whenever a question under the Armed Career Criminal Act arises. And, he says, the first time a question arises under the Armed Career Criminal Act is when a person commits a federal firearm offense. The reference canon can be a helpful tool, but Jackson misuses it. That canon provides that a statutory reference to a general subject incorporates the law on that subject as it exists whenever a question under the statute arises. but a reference to another statute by specific title or section number, such as the Armed Career Criminal Act's reference to 21 U.S.C. 802, in effect cuts and pastes the reference statute as it existed when the referring statute was enacted, without any subsequent amendments. That part of the reference canon undermines Jackson's position. Jackson attempts to rescue his argument by asserting that the Armed Career Criminal Act's mention of the Controlled Substances Act is actually a general reference. To support this argument, he cites cases that treat statutes as adopting the general law on a subject, even though the statutes referred to that general law in terms of the sections of the statutes in which it is to be found. But even if we assume that there may be contexts in which references to specific statutory provisions may be considered general, it is hard to see the phrase as defined in Section 102 of the Controlled Substances Act as anything but a specific reference. And for reasons already set out, the context here does not help Jackson. As we have explained, his reading would treat a state offense involving a controlled substance defined in the Controlled Substances Act differently from a federal offense under the Controlled Substances Act, even though both phrases make reference to the same act. That approach would give defendants with prior state offenses the benefit of subsequent amendments to the Controlled Substances Act, but would ignore those same amendments for prior federal offenses. In that context, Jackson's reliance on the reference canon is clearly unpersuasive. Alternatively, Jackson says that his reading is required by the settled legal principle that the law that sets the penalty for a federal crime is the law in place when the crime was committed, and to show that this principle supports his reading of 924 E2 A2, he offers a series of hypotheticals involving amendments to the Armed Career Criminal Act. Here is one. If Congress deleted drug possession from the list of serious drug offenses, he argues, no one would think that someone who committed a federal firearm offense after this change would be subject to the Armed Career Criminal Act based on a prior state conviction for drug possession. Therefore, he maintains the same should be true for amendments to the schedules. This argument begs the question that these cases present, which is whether 924E2 A2 is amended with every change in the drug schedules. Jackson imagines a version of the Armed Career Criminal Act that plainly would not apply to a prior state offense because that version would no longer list drug possession as a serious offense. And he then reasons that the same result should obtain here. But in his hypothetical 924E was amended. Here, only the federal drug schedules were changed. Jackson's argument that a change in the federal drug schedules equates to a change in 924E2A2. A2 is thus nothing more than his reference. Canon argument dressed in different garb. And for the reasons we have explained, we are convinced that the canon does not work in the way he suggests. In all events, Jackson's emphasis on the law in place when the crime was committed is a red herring. Section 924E2 2 currently means that a prior state drug conviction may constitute and the Armed Career Criminal Act predicate if the drugs on the federal and state schedules matched when the state drug offense was committed. Thus, contrary to Jackson's suggestion, treating his prior convictions as the Armed Career Criminal Act predicates is entirely consistent with the settled legal principle that current law sets the penalty for a federal crime. The dissent agrees with Jackson's interpretation, but for a different reason. It believes that all cross-references plug in the referenced provision as it exists at the time of the statute's interpretation. Thus, the Armed Career Criminal Act's reference to the Controlled Substances Act must incorporate the federal drug schedules that are currently in effect for sentencing purposes, those that were effective at the time of the federal offense. The problem for the dissent is that none of the cases it cites supports this proposition. For good reason, as we have explained, cross-references sometimes refer to the law as it currently exists, but they may also incorporate a reference statute as it existed when the cross-reference was enacted. Indeed, Many of the dissent's cases stand for the unobjectionable proposition that courts must carefully consider the text and context of each statute before adopting a one-size-fits-all approach to cross-references. Following the approach laid out by the dissent's cases thus brings us back to the question with which we started. What is the best reading of the Armed Career Criminal Act's cross-reference in light of context, precedent, and statutory purpose? For the reasons we've explained, it is that a prior state drug conviction constitutes and the Armed Career Criminal Act predicate if the drugs on the federal and state schedules matched when the state drug offense was committed. We turn next to Brown's interpretation, which would require the state and federal definitions to match when the defendant is sentenced for a federal firearm offense. Brown first argues that his interpretation is grounded in the Armed Career Criminal Act's text because it focuses on the here and now import of historical facts. Specifically, Brown notes that the Armed Career Criminal Act uses the present participle of involve rather than the past participle, and he suggests that the phrase as defined in is likewise in the present tense. Unfortunately for Brown, we have already rejected this textual argument. The petitioner in McNeil likewise argued that the present tense language in the Armed Career Criminal Act's definition of a serious drug offense indicated a present-day focus. The court declined to do so and held that the Armed Career Criminal Act requires a historical inquiry into the state law at the time of the prior offense. The use of the present tense did not suggest otherwise. McNeil's conclusion makes sense. Use of the present tense, as opposed to the past, was likely a stylistic rather than a substantive choice. Around the time of the Armed Career Criminal Act's enactment, legislative drafters were instructed, whenever possible, to use the present tense rather than the past or future. So, at least in the instant context, we cannot place too much weight on the use of the present tense as opposed to the past. Brown also claims that his reading is required by United States v. Schooner-Peggy, which says that when the law changes while a case is in progress, the case must be decided under the new law. But that principle does nothing to advance Brown's position. Section 924E2. A2 has not changed at any point in the litigation, from the time petitioners committed their federal offenses until today. Then, as now, under 924, past state drug possession offenses may qualify as the Armed Career Criminal Act predicates if the federal and state schedules matched when the state crimes occurred. We conclude by addressing some additional arguments advanced by both petitioners. First, they assert that our interpretation should be rejected because it is under-inclusive specifically, because it would preclude the Armed Career Criminal Act enhancements for state offenses involving drugs added to the federal lists only after the state crimes were committed. But none of the parties' interpretations captures all cases involving career criminals. Indeed, Brown and Jackson are themselves asking to be exempted from the Armed Career Criminal Act's reach, even though they both have a history of dealing drugs that remain prohibited by federal law. Second, petitioners suggest that the government's interpretation is absurd because it would exclude from the Armed Career Criminal Act's reach all state drug convictions from before 1970 when the Controlled Substances Act was enacted. But whether or not this consequence is desirable, it is not absurd. We can easily see a reason why Congress might have chosen not to count either federal or state drug convictions that occurred before 1970. Before that time, Congress enacted more than 50 pieces of legislation relating to dangerous drugs, and this had given rise to a confusing and often duplicative approach to enforcement. The Controlled Substances Act was designed to replace these scattered provisions with a single comprehensive statute. It was reasonable for Congress to peg the Armed Career Criminal Act's penalties to that new comprehensive regulatory scheme rather than requiring courts to grapple with the welter of federal drug laws that previously existed. Petitioners argue that the government's interpretation would unduly burden courts and defendants by requiring them to undertake the laborious task of digging up old federal drug schedules and comparing those to the state laws the defendants violated. But the difficulty of this task is overstated. Most drug convictions concern just a few drugs, and the federal and state definitions of those drugs do not often change. In the cases now before us, the courts below had no apparent difficulty finding the needed information. Finally, both petitioners contend that the rule of lenity counsels us to adopt their interpretations. It does not. Lenity applies only if a statute remains grievously ambiguous after we have consulted everything from which aid can be derived. As we have explained, however, context, precedent, and statutory design adequately show what Congress intended. In any event, neither Jackson's nor Brown's interpretation would be preferable for all defendants. Both interpretations could hurt defendants who committed or were sentenced for the felon in possession offense before the addition of a drug to the federal schedules. As petitioners' own briefs highlight, states sometimes criminalize drugs before the federal government does so. For instance, Florida banned a stimulant known as bath salts 10 months earlier than the federal government, and Utah criminalized the hallucinogen methoxytamine nearly a decade before the federal government followed suit. State convictions for those drugs that predate the federal amendments would not count as the Armed Career Criminal Act predicates under the government's interpretation, but may under petitioners' interpretation. It would be odd to use the rule of lenity to help petitioners but harm others. For these reasons, we hold that a state drug conviction counts as in the Armed Career Criminal Act predicate if it involved a drug on the federal schedules at the time of that offense. Accordingly, we affirm the judgments of the courts of appeals. It is so ordered.